The Liberal Party is struggling to keep Mark Carney's conflicts of interest under control.
The Liberals' Bill C-15 creates a new power for ministers to exempt companies from federal laws, and this can be done in secret. This opens the door to conflicts of interest that Parliament and your office might never see. If a minister can grant exemptions and they can be granted to companies that they are connected to, and even conceal their orders from public release, won't this at a minimum make it harder to detect that a conflict of interest exists? But doesn't it also create the opportunity for real conflicts of interest to occur with no effective oversight whatsoever?
Just because the minister is authorized by statute to do something doesn't mean he can avoid the conflict of interest to act. So if it is part of his function to exempt the company, he can do that. If there, however, is under the act a conflict of interest, as you suggest in your example, then he has to recuse himself. The act is quite clear. He cannot participate in the decision. He can't even be in the room. He has to leave and absence himself when that decision is made.
It appears to be a systemic gap that's being created, though, Commissioner. It's a path for ministers to bypass the usual parliamentary safeguards and ethical scrutiny by shifting decisions into private exemption orders. Does that not present a cause for concern for parliamentarians?
I'm not sure I follow you. How, Mr. Baird? Where is the shifting taking place here?
The effect of their orders is not public, and they can exempt the normal release of information that we would see, and it's for a period of years, and there would be no detection that it has occurred. So we assume that the minister leaves the room, but oftentimes we find out only that a breach has occurred because of the release of information, access to information requests, inquiries of ministry, order paper questions, and the like.
When you say the exemption is secret, you mean the act authorizes the minister to make a decision and it not to publicize it?
The information does not need to be publicized in the Gazette.
Yeah, but I'm sorry, if the company is exempted, that means if they weren't exempted, they couldn't do this. So presumably, the exemption has to be published somewhere.
Well, one would hope that through the transparency that's required, then yes. But that's not the effect of the Budget Implementation Act, Bill C-15. Your question, your question that I've provoked is born out of the same expectation I think that Canadians have about transparency and openness that we expect from government, when instead there's we're moving off the path of normal government and into exemptions to all laws except the criminal code is what the act says.
Okay. Well, first of all, C-15 is not law yet. It has to be passed by Parliament. Secondly, the obligation not to act in contravention of the conflict of interest is there. The minister cannot make such a thing. Now, you posit that he will make an exemption which benefits himself and people do not know about it. I always have difficulty answering a hypothetical question. If you give me an actual case and actual facts, I can answer that. I don't quite see how we can have a secret exemption. The effect of the exemption will be public, and people will ask, like you, why is this company doing it when normally an act would require A, B, and C? Where do they get the authority?
To be clear,
so therefore, somebody will say there is an exemption. Here it is.
So to be clear, I don't see the mechanism in the legislation that would publish the exemptions that are able to be made to all laws except the Criminal Code, including the Lobbying Act, including access to information laws, and including the Conflict of Interest Act. But am I to understand then that the law as it's written, and should it come into force, without giving any hypothetical examples, that it gives no rise to concern for you?
The Act, Parliament has the authority to enact what they want. As you know, the Parliament is supreme. And if they will act that, we will look at the Act. I have not looked at it from this particular aspect that you mentioned, but I cannot understand the rationale how you can have an exemption that is secret and will not be. It's, after all, it's an authorization. It has to appear somewhere.
Well, the expectation I think that Canadians have is, as Parliament is supreme and has passed laws, including the Conflict of Interest Act, the Lobbying Act, access to information laws, that there's no reason for a government to put forward legislation that gives them the opportunity to exempt themselves from all laws except the criminal code. I think that Canadians should be rightly concerned, and I certainly am.
Okay, thank you, Mr. Barrett.
Thank you, Mr. Chair. Welcome, Commissioner. Welcome to your team. Mark Carney's ethics screen that you set up lists 103 companies, almost all of which are Brookfield companies. The chief operating officer of Brookfield, Justin Bieber, told this committee that Brookfield owns 2,000 companies and businesses. Do you have a full and comprehensive list of all of Brookfield's companies and businesses?
We have a list of what the Premier Minister and his lawyers furnished us, and it is attached at Annex A to the screen.
So you do not have a full list of the 2,000 Brookfield companies?
No.
Okay. So Mark Carney holds stock options and deferred share units in Brookfield, potentially worth tens of millions of dollars. The chief operating officer of Brookfield said that in respect of Carney's stock options and deferred share units, quote, as the value of Brookfield increases, the value of those instruments increase. So accordingly, it follows that as Brookfield-owned companies do well, Brookfield does well, and by extension, Mark Carney does well. So if you don't have a full list of the companies, I would put it to you that you are missing potentially a whole long list of conflicts of interest or potential conflicts of interest that Mr. Carney has with Brookfield companies.
The Annex A to the screen lists the first five companies. This is really the ones who own all sorts of other, the rest of those, directly, indirectly, or in which are dealing with those. It's clear that Mr. Carney's compensation is tied to the future compensation is tied to the success of Brookfield. But in order to avoid that he makes a decision which can be seen to benefit Brookfield and thereby indirectly himself, he has set up, first of all, he's put everything in a blind trust, but secondly, he set up the screen to make sure that any decisions that he makes regarding the five key holding companies, he is, or the ones that he knows about.
Commissioner, I think you said it exactly right, that Mr. Carney's portfolio is tied to Brookfield. As Brookfield does well, so does Mark Carney, and yet 95% of Brookfield companies are not subject to the screen. How do you explain that?
I don't know where you get these 95%. What you have before you is his statement saying these are the companies that he knows about, and he, etc. And then the entities that appear before the lobbyists, and also the entities that were defined by our office, etc. That's essentially the universe we know about, and as he himself says in Annex A in Item C, that I had no role in managing them and no direct financial interest in them. So now you're saying he has a financial interest. I don't know how you are you contradicting the statement made in Annex A?
I'm simply referencing what Mr. Bieber said, and in light of the fact that Mr. Carney has stock options and deferred share units, and I know that we saw a letter from Brookfield today that merely dismisses these companies as de minimis. Are you just taking Mark Carney and Brookfield at their word? Or have you sought to get further information? Given Mr. Bieber's testimony that there are these 1,900 other companies, are you going to go back to Mr. Carney and go back to Brookfield and say, provide us with a list of those companies to determine whether or not additional companies should be added to the screen?
Lynn, do you want to answer that?
So, essentially, when the screen is a preventative measure, it's there to anticipate conflicts of interest. It's not there for the Prime Minister to avoid a conflict of interest. So, for all intents and purposes, if a matter is brought to the Prime Minister's attention, and the Prime Minister is aware that it would further the private interests of Brookfield, then he would have to recuse, even if the screen did not capture that item because it's not on the
I understand
annex.
how the screen works. Yeah. I'm just asking, why will you undertake, or are you intending to get a list of those companies in light of Mr. Bieber's testimony? That was my question.
Okay.
Well, of course, we looked at these companies and to make sure we know what the interest of, and most of them, as Mr. Bieber said, are de minimis.
Right.
But any kind of deferred compensation that you
are taking
Thank you.
Brookfield at their word.
I'm going to have to cut it off there.
The breakdown is quite simple. If Brookfield and surrounding companies do well, their stock will go up, and therefore, Mark Carney will make money. And the more I hear about this screening process, it's quite obvious that it is a complete joke. 95% of Brookfield companies are not subject to the screen. 1,900 total. This just screams conflict of interest after conflict of interest in a long line, a massive laundry list. Anyway, I would like to know what you think down in the comment section below. Hit that like button, hit that sub button if you are new, and thank you very much for watching.